Welcome to the Capital Forum interview series. I'm Sania Rao, and I'm a senior correspondent with the Capital Forum. And joining us today is Michael Murray from Paul Hastings. Michael works as the co-chair of the Antitrust and Competition Practice and also served in the first Trump administration. So we're really grateful to have your perspective. Thank you for your time.
Thank you for having me.
For starters, can you walk us through a few substantive changes in the antitrust enforcement in the second administration and how that's influencing deal making?
Sure. I think there are two big changes that we see on a day-to-day basis. The first is the openness to settlements. It's a change from the past administration where they were less focused on how a case could be resolved. And so we're seeing early and often engagement on the idea of a remedy, whether that's a structural remedy, which is preferred, or a behavioral remedy. And that's a pretty significant difference. And that feeds into the second difference, which from my perspective, I see a lot more transparency and engagement with the enforcer, either the FTC or the DOJ, from the beginning. So it's much easier to get a sense of what they're concerned about, what they might be focused on, where they're looking, and that also informs the potential remedy discussion. So in general, it's a time where there's more transparency, more engagement, and more openness to a remedy type solution than in the past.
Absolutely. Just thinking about settlements a little more, we've seen a lot of discussion about the return to settlements and how that has influenced merger enforcement. And I know you worked in the divestiture part of United Health's acquisition of Medicis. So how do you think that settlement provided early signals on how this administration might be thinking about merger enforcement?
So I think there's a lot of factors that were at play in that settlement. It was a very big case and landmark in many respects. But I think what it really shows most of all is a return to some of the thinking that I at least had when I was at DOJ, which is that at times an agency can obtain a significant win that maybe is not 100% of what they want, but maybe it's 75%, maybe it's 80%, maybe it's 60%, but at a significantly lower resource allocation. And so from an enforcement perspective, that's a statistical decision really, that most agency decision makers are willing to make consistently over time because it's better overall for the American people to have 75% remedies with 25% of the resource allocation as opposed to going for all or nothing with the prospect of litigation. And so that, I think the United Health and Medicis settlement is one example of that. There are other examples, but I think that's one example of that type of thinking being back in the forefront from the past.
So more of a solution-focused approach.
I think for sure it's definitely an approach that's focused on finding the best solution in this particular circumstance, given all of the factors that are at play in an enforcement decision. One of the big distinctions that I think is coming more to the forefront now is the distinction between sort of pure antitrust law and antitrust enforcement. Those are actually different things. Antitrust enforcement is weighted by resource allocation, by policy priorities, by the priorities of other agencies in the administration, whether we call that whole of government or unitary executive. That's a different question than what is the pure antitrust law answer to this merger. And I think we're seeing more and more focus on the enforcement as opposed to the law piece.
Absolutely. Thank you for breaking that down for us. Thinking about healthcare industry, do you think there's a lot of daylight between how the DOJ approaches merger review and how the FTC does so? We've seen some cases on the FTC side go to litigation with GDCR and Genevalve. I was just curious about curious about how you think about these cases. Or is it more that we've seen more cases on the DOJ, FTC, so we have more of their perspective, or just your thoughts on that front?
So I don't see a lot of distinctions between the agencies. To be clear, there are procedural distinctions. There's different groups, different personalities, and so there's that. But on the whole, in my sense, is that they're enforcing essentially the same type of priorities and essentially the same type of manner, and any distinctions in case outcomes or litigation versus settlement is more based on the facts of a particular matter, as opposed to some difference in policy or priority or a personality.
Thinking more about the DOJ, there's been a lot of change at the top in the past year, and I'm curious, from your perspective, how has it changed the pace and focus of merger reviews from a day-to-day perspective?
So generally speaking, the agency at DOJ and the staff members have remained incredibly hardworking, dedicated to the public interest, dedicated to getting the right answer. And I think on any particular matter, the resources are there to pursue that matter when the agency chooses to pursue it. I think what the decision makers are having to do from a resource allocation perspective is pick and choose which matters. Now, that's always true. There's always more matters that agency head may want to pursue than they have the resources to do. It's become more of a focus in the press and the bar as the headcount has perhaps decreased. But it's the same type of decision that I think was being made. And all credit is due to the front office leadership and the staff for when they're a part of an investigation, really pushing that along, trying to make progress and working really hard. When I was at the agency, I was always impressed by the staff's nights, weekends. We got to leave no stone unturned, work really hard, get the right answer for the American people approach. And I think that's still the case now.
How about difference in terms of engagement with deal parties?
So I think right now there's, in some ways, a return to Trump 1 in the level of engagement early, often, and transparency. So it's and that's a welcome development. I think that would be universally acknowledged as a welcome development, that the merging parties feel like they can get more clarity about the scope of the investigation early on, about what the focus is, what the priorities are for that particular case, and that people are willing to have meetings, to have phone calls, and I think that is a directive and an exemplary issue, right? It comes from the top in terms of where they're directed to spend their time, but it also is an example. If the front office and the higher ranking career officials are taking the time to do those meetings, to have those communications, it trickles down and it becomes a culture. And I think that's a huge improvement in the past year or so.
Is there any concern about the institutional knowledge leaving the building?
So there's always turnover, and I think it's important to break down the turnover into 3 different areas. There's sort of generalized expertise of people who've been there for a long time. That's one. Second, there's industry expertise. And third, there's particular case expertise. Most of the conversations actually focus on the first, generalized expertise, people have been there for a long time. But in some ways, that's actually the one where the institutions are the deepest and they have the most ability to sort of continue on. The hardest one is actually the second one, where you might have someone who's a specialist in a particular niche market. There might only be 1 or 2 people at the agency who have done a deal in that space in the past 5 years. That type of attrition, whether it's a retirement or something else, that can be harmful, but it doesn't usually affect the outcome. The agencies are staffed by really competent people. It sometimes affects the timing. Sometimes things that might have gotten through in 30 days, maybe they take 60 days. So there's a pull and refile. But it's not usually outcome determinative in my experience.
Thank you. I do want to focus a little bit on policy. One of the first projects taken on by Chairman Ferguson in the second Trump administration was his Joint Labor Task Force. How have you seen that being implemented? Are you seeing more questions from the agencies? Is that something you're more actively thinking about?
For sure. At some level, it's a continuity from actually President Obama's administration in 2016 with the guidance document that came out, I think, in October of that year, through the first Trump administration with the first indictments for wage fixing and no-poach agreements, then through the Biden administration. So in some sense, there's continuity, perhaps unexpected from some quarters, but I don't actually think it was unexpected if one has read the speeches of Chair Ferguson, of Assistant Attorney General Slater, or even Commissioner Metter and Acting Assistant Attorney General Sefi. One can see a real focus on kitchen table, pocketbook issues. And what is more kitchen table or pocketbook than labor mobility and wages for employees? And so it's not surprising. And from the private bar's perspective, we do get a lot of questions from our clients about how to interpret various decisions, various statements, speeches. And that is an important part of our day-to-day counseling.
Absolutely. I do want to end with my favorite question as a reporter, and which is, what's one thing we didn't talk about, but that we should be keeping an eye out for as we go into the next 3 years or the next year?
Sure. I think next year we'll be talking a little bit more about personnel. So there's a nomination to the FTC of a new commissioner who's a business person, which is actually not that unusual in the history of the antitrust agencies, but is relatively unusual in recent history. And so I think we'll be talking about the experience and expertise that person brings and the distinction that person will help draw out between pure antitrust law and antitrust enforcement. One of the premises of antitrust law is that there are people who bring different perspectives, different expertises. And I think it'll be a welcome addition to have a business person as an FTC commissioner, just like we might have academics or economists or lawyers to kind of have that additional perspective.
They are going to have different perspectives, all three of them, which will be fun to see.
Yes, I think it'll be very interesting to see how that shakes out, and there might be other personnel changes as well, although those are harder to predict.
Well, we really appreciate you speaking with us today. This was extremely insightful. Thank you so much for your time.
Thank you for having me.